Welcome to this webinar, which is brought to you by the Garden Court Chambers mediation team on mediation and how it can work for you. And this is part of events during Mediation Awareness Week. My name is Liz Davis. I'm a barrister at Garden Court in Housing and Public Law, and I've also been a mediator practicing from Garden Court for many years. So our agenda today will be an introduction to family mediation, followed by the recent amendments to the civil procedure rules and we will end with tips and tactics on preparing for mediation and obtaining a successful mediation. For litigators these days, then an ability to represent your client in mediation is just as an essential litigation skill as any other litigation skill. It's absolutely necessary. And the rules of court in both family procedure and civil procedure have recently this year been amended in order to emphasise the point that parties to litigate should be prepared to mediate. And if they're not prepared to mediate, then they have to explain why not. And the court has powers to penalise those people in costs. So litigators need to be skilled at mediation because of the new rules and the new approach by the court, but also because successful mediation is a goal in itself. A successful mediation saves the parties huge amounts of legal costs, the stress of undertaking adversarial proceedings, and the uncertainties that we all know litigation brings. And one of the many things that's great about mediation is that it allows for remedies that are beyond the powers of the court, precisely because a successful mediation settlement can be achieved where the parties agree and they can agree on absolutely anything that they want to agree on. So such as an apology, making clear that one party has an understanding of the other person's point of view. Anything that can be agreed can be part of the settlement in a mediation, and those remedies go far beyond the powers of the court. We have three very experienced mediators presenting today's webinar, all from Garden Court Mediation Team, and we're going to give you both the legal framework and the tips and tactics when preparing for a mediation and undertaking the mediation itself. I'm going to introduce all three of them right now, and then each will speak one after the other. We will start with Lyndsey Sambrooks-Wright, who is a family law specialist and a court of protection specialist barrister at Garden Court. And the legal director has described her as able to explain complex legal problems and concepts in an easy to understand way to lay people and able to get to the root of problems very quickly. And that's exactly what you need, both from a mediator and also from a representative in a mediation. And she's going to deal with family mediation. Marina Sergides will be our second speaker. She's a housing law barrister at Garden Court. And the legal director has described Marina as good at thinking outside the box, that she can find solutions that are not always obvious. She has an attention to detail and a calm and approachable manner whilst remaining clear and authoritative. And again, I would say those are exactly the qualities that you want in a media. And we're very lucky to have Marina because she's extraordinarily busy, not only with her housing practice, but she's represented domestic abuse forums in the COVID inquiry last year, and that's ongoing. She's going to deal with the recent changes to the civil procedure rules and the implications for legal costs arising out of the Churchill and Merthyr Tydfil judgment. And we will finish with David Watkinson. David is a retired barrister, but a very much still practicing mediator. He is, those of you who practice in housing law will know him as one of the founders of housing law. If you put his name into the housing law reports, all the important cases come up. And he uses the litigation and advocacy skills that he built up in his 40 years in practice now in mediation. And he's known for being able to seek the common ground, for putting people at their ease, and for assisting parties in finding solutions. I just need to deal finally with housekeeping. This event is being live streamed and recorded. You all agreed to being recorded when you came into the webinar, and the recording will be uploaded to our YouTube channel with the links and the slides being sent out to all attendees. We will take questions for the end of the session, Please put any questions in the Q&A box, not in the chat box, and I will monitor the Q&A box and I will then put them to the relevant speaker at the end of the webinar, time permitting. If there are lots, then we won't obviously be able to take all of them. And I should say, and this is important, that we cannot comment on specific and ongoing cases. We can comment on the legal principles and the mediation principles in general. We will aim to finish at 2 p.m. because you're all giving up your lunchtime for this. And without further ado, if we can have the next slide, please, and I will move on to Lyndsey Sambrooks-Wright. Lyndsey.
Thanks, Liz. Welcome, everybody. Thank you for joining. You all have different areas of expertise. So some of you will know the area that I'm about to discuss quite well. Some will be far more familiar with it than I am, perhaps, and others will not. So I'm going to start with an overview about family mediation. So family mediation is quite distinct in the sense that it shares some common principles with civil mediation, but it also very much has its own aims. It's voluntary, with the caveat that the mediation information assessment meeting is no longer voluntary, and I'll address that later on. Entirely confidential, again with the caveat that this is very rare unless there's a risk of harm or criminality. I haven't come across that in 10 years of practice. It's impartial, it's much quicker and much more cost effective than most family court proceedings, and those family solicitors here will be very familiar with the delays in the family courts, the difficulties in getting a hearing, and generally the short hearing length to deal with myriad issues. The beauty of mediation is that you can personalise a session to the points that are important to your clients. So as Liz has said, it really can cover pretty much anything, as long as if it's a financial case or if you're looking for a consent order, it's within the boundary of what the court would consider reasonable. But certainly there are multiple issues that can be dealt with in family mediations that I'll detail in a moment. The other point to note with the personalisation is it can be child inclusive. So there are specialist child inclusive mediators who would take a child's view, if depending, of course, on their age and when it's appropriate. So it really does mirror the approach in the family courts, that there's no set age, but depending on a child's maturity, it would be unlikely that a mediator would be talking to a child younger than perhaps, say, 7, 8, as a very wide ballpark. And they can feed those views back into the mediation when it's appropriate. It's really beneficial in certain cases for the parents to be able to hear what the child is saying in a really child-friendly way without putting the pressure on them of being involved in court proceedings. And it's really successful. So nearly 70% of cases in family mediation resolve all or some issues. And again, I will discuss the cases where actually important issues can be resolved even if you don't reach a final settlement. Finally, just to note that ongoing communication in family cases is vital, that this isn't a scenario where you will ever be rid of the other person in the mediation. If there are children involved, they'll be in your life until the children are of adult age. So improving communication without there being any hint of counselling or anything of that nature is a really vital benefit of family mediation, and it's regular feedback really that I get that parties do feel much more able to actually discuss issues once they've sat down and had a reasonable conversation about it in mediation. So the areas covered, and this is a very short list of a long list of areas, they follow obviously the normal issues that come up in the family courts, so contact, live with orders, disputes around where a child should go to school, applications to relocate, perhaps out of the country. Medical treatment is one that's come up in a number of mediations, and I'm not, of course, straying beyond the family courts. These aren't court of protection issues, but where you have a child with specific needs or extra accommodations, perhaps in a house, that are needed, then it's quite useful to be able to sit down in mediation if there's a dispute about that and have quite a detailed discussion. And certainly I've had cases where children will have ongoing needs into adulthood, and multiple practical arrangements can be put in place through mediation that really eases the position for both parties, particularly when you're looking at splitting households and setting up 2 different properties, as people generally are. In terms of finances, then obviously there are much more standard cases looking at how to split the equity in a property, but there's also quite complex cases that can come to mediation that can include consideration of businesses, of pensions, and that's when a mediator can either co-mediate or, as I often do, bring in expert advice, so a pensions advisor, a financial advisor. I'll quite often sit in that session with permission of the parties, so I can hear the information that's being discussed. One of the questions that I'm quite regularly asked in the MIAM, particularly the Mediation Information and Assessment meeting, is what happens if there's been domestic abuse? And there are specific exemptions to attending a MIAM, which I'll outline, which includes significant domestic abuse, generally with evidence in some respect. There are cases where there might be more historic abuse or perhaps fewer instances where the parties are more comfortable to mediate, but there needs to be something put in place to deal with any power imbalance. And that's when mediation can get quite creative. So even if it's a mediation that's taking place remotely, as a lot of my mediations are at present for the convenience of the parties, then you can have shuttle mediation remotely, where you have two different rooms effectively on Teams or on Zoom, and the parties are never directly talking to each other, but the mediator will go between the two, just as I would in two literal rooms, and then they can feed in their views. It sometimes happens that it can start that way, and then parties can feel comfortable to come into the same room together after a while. And also in the background, there is vital legal advice taking place at regular intervals, including particularly in financial cases. And that's before any final settlement is reached as well. The parties will be sent off to take legal advice on the proposals. And there's also, of course, other support services who may actually, unusually, sometimes attend the mediation to support the person. So who's required to attend a MIAM? For quite a few years now, anyone applying to the court for an order about children or finances has to attend a MIAM, which is the Mediation Information Assessment meeting. They're generally quite short, about 45 minutes. They're almost always done remotely. And what they do is they provide information about mediation, and now with the recent changes about all of the relevant non-court dispute resolution. So I have to go through a list of other issues, other options that might be available to the parties. And during the MIAM, I will also obtain information about the individual, about the family, look at the suitability of mediation. There are cases which in family are simply not suitable for mediation, and then that box will be ticked and the application can be made to the court. Respondents don't have to attend MIAMs, but as we'll see, the direction of travel in the courts is becoming quite critical, really, of people who choose not to engage in NCDR. The main exemptions, and I won't go through all of these because they're in part 3 of the family procedure rules, but evidenced domestic abuse, urgency, so risk of harm, perhaps if somebody is going to make an application in another jurisdiction or in danger of frittering financial assets, where the child has local authority involvement. One of the main ones to note is that there was previously a strong exemption, really a foolproof one, that if you'd been to a MIAM or attended a mediation within the last 4 months, you were exempt from doing another MIAM. The changes in the court now means that that's no longer necessarily the case, and judges will examine the exemption that's being claimed. So it's important for solicitors to be very clear. And if in doubt, I would suggest attend the MIAM to avoid the delay of having the case adjourned and somebody packed off back to the mediator after the court hearing. I won't go through the legal aspects in any detail. I'm aware that the Merthyr Tydfil case will be addressed elsewhere, but just to note 2 cases. One is K&K in 2022, which was a case involving serious allegations of rape, coercion and control. And the interesting point in that case is that the parties were nonetheless criticised for not having attended a MIAM. That's an oversimplification of a very important case, but it does really shadow the direction of travel that we now have, which brings us to 2024 Re-X, where Mrs. Justice Knowles, it is highly, again, quite critical of the parties for not having engaged in a MIAM, not having considered NCDR, and really enforcing the fact that the court should be a last resort rather than the party's go-to option. NCDR needs to be considered at every stage of proceedings. What Mrs. Justice Knowles referred to in that case were the changes that came in April, which were just after that case, to the family procedure rules. Part 3, Practice Direction 3A. Again, I've done detailed slides, so you won't need to listen to me go through them all in detail, but the main points to remember is the court has for a while had a duty to consider NCDR at all stages, and they still can't direct that the parties in family go to NCDR. It's not compulsory, but they're told to encourage the parties to consider or attend NCDR. And encourage becomes a little bit loaded in the context of the recent changes. The boundaries are becoming slightly blurred, because what the court can do as part of that encouragement is adjourn hearings to enable parties to do that, which of course has cost implications. And then we'll look at the next slide for some of the other elements that the court has at its disposal. Parties are required to file and serve a form FM5, setting out really why they aren't prepared to use NCDR, and that can be analysed in the hearing. And of course, the MIAMS exemptions, as we've discussed, have been limited in various ways. So in the round, the court, whilst encouraging the parties to attend mediation, has actually got quite clear tools at its disposal to make sure that that does take place. One of the final resort tools is costs, which are, as the family solicitors will know, quite rare in family proceedings, very rare when it comes to matters dealing with children. There's almost a blanket rule that costs aren't applied. But in financial issues, then costs can be a method for the court to enforce NCDR. And we're certainly seeing more cases, including re-ex, where the court is willing to resort to that. So whilst it wouldn't necessarily affect the outcome of the case, then the court can consider whether a party has failed without good reason to attend a MIAM or to attend NCDR. It will be interesting to see in the coming months and years what the court does consider to be a good reason in terms of failing to attend. Again, I've done a detailed slide, so I won't go through this step by step, but a couple of points to note about the process of family mediation. One is that at the end of mediation, what's often not known is that something called a memorandum of understanding will be put together, which is a summary of all the points discussed, agreed in mediation. And that forms the basis for a consent order that the solicitor will put together, again, often in financial cases, and send to the court. Attached to that will be the open financial statement. So whilst the memorandum of understanding is without prejudice, the open financial statement is an open document, and that puts together all the information coming from the financial disclosure from the parties. And that really is intended to make this solicitor's job extremely easy when drafting the consent order. The benefit, of course, as a barrister mediator is that I know roughly what should be in there, so it shouldn't contain any surprises for the mediator drafting. And in child cases, you can have a parenting plan, looking forward, setting out contact arrangements, and that tends to be quite successful. There's only really a couple more points to note. One is mediation, family mediation isn't a protected profession, but it's only accredited mediators who can sign the form FM1, and that's the form that you'll need to certify to the court that you've attended a MIAM, or that your mediator doesn't consider that you should need to. There's a link where you can find accredited mediators on the Family Mediation Council website. And the other one to note is the voucher scheme, which on a practical basis can be quite useful. It's a £500 voucher. It can't be used for a MIAM, but it can be used for the initial mediation sessions, and your mediator will apply for that. So that's one to bear in mind when discussing mediation with clients. I hope that was helpful. Thank you, Liz. Back to you.
Lyndsey, thank you very much. That was a fantastic pointer through family mediation, and several of David's tips and tactics towards the end of this session will be relevant to family mediation as well as to civil. So Marina, take us on to recent developments in the law governing civil mediation.
Thanks, Liz. Thanks, Lyndsey. That was really helpful. I'm going to talk about civil mediation. Again, I've got some slides to refer to, and I'll get straight in there with the case that I'm sure many of you have heard about, Churchill and Merthyr Tydfil. So this is a 2023 Court of Appeal case, and you'll see from the slides that lots of people intervened in this case. It had a big impact for many organisations, and you'll see the first bullet point, the Bar Council, the Law Society, Housing Law Practitioners Association, and a number of others. And that's because, of course, it had wide implications, I should say, for us practicing in civil law. So the factual background to the Churchill case wasn't particularly that interesting. I should briefly mention that it concerned a nuisance claim in respect of Japanese knotweed, which many of us will know is notorious for being difficult to control. And Mr. Churchill was very annoyed about this, understandably, and he brought a claim against his local authority in nuisance. And his local authority said, well, hang on a minute, we've got a internal mechanism to deal with this. It's essentially a type of mediation stroke ADR. It's non-court based, and we would like to adopt that process before continuing with this litigation. And Mr. Churchill and his lawyers said, no, we want to crack on. That's a very, very short summary. This ended up before the judge in the lower court, who said, essentially, again, I'm summarising, that whilst it was contrary to the spirit of the practice direction on pre-action conduct and protocols, and certainly whilst he would have liked to have seen Mr. Churchill agree to this alternative way of resolving matters, he could not oblige the parties and could not refer the matter to a mediation. And he said he was bound by the case of Housley and Milton Keynes General NHS Trust. He said that to force the parties would be an unacceptable obstruction on their right to access to the court. The Court of Appeal did not agree, and they felt that Housley Milton Keynes General NHS Trust was not binding. And they essentially, again, I'm summarising, confirmed that the court could order the parties to engage in ADR. The Court of Appeal held that it did not breach Mr. Churchill's Article 6 convention rights. And whilst it declined to lay down any fixed principle on when the court should stay proceedings for the purpose of ADR, it did consider all the number of factors that the Bar Council put out in their submissions. So I haven't listed them here, but there are some general points that can be considered when the court does decide, if the court does decide to stay proceedings for the purposes of ADR. So it was a welcomed decision by many, particularly those that intervened. And what did it lead to? So it led to the Civil Procedure Amendment number 3, Rules 2024, statutory instrument that I've cited in the slides. And it made some very important changes to the Civil Procedure Rules. The explanatory notes to those civil procedure rules state very clearly that the reason that the rules have the CPR has been changed was in order to bring it into line with what the Court of Appeal said in Churchill and Merthyr. So that's expressly stated in the explanatory notes. The first most important change, of course, is a change to the overriding objective, and I've cited the relevant change there as Rule 112F. And that is that now, as part of the overriding objective, the court must consider promoting, and in fact, the parties must consider promoting or using alternative dispute resolution. And we know from the remaining parts of CPR Part 1 that the court must seek to give effect to the overriding objective, and the parties are also required to further the overriding objective. So it's for the court and all the parties now to very much have the alternative dispute resolution in their minds when issuing or pursuing any claim. It goes further, of course, and again, I've cited bullet point 2, you'll see as rule, again, under CPR Part 1, that shouldn't, you'll see under bullet point 2, and I've put Rule 112E. That's a slight error. It should be 14E. So please do amend that when you do get the slides. But again, there's a very important change to the overriding objective, which is set out there, which is the court's duty to manage cases includes ordering or encouraging the parties to use and facilitating the use of alternative dispute resolution. So when you issue a case, when you pursue a case, when thinking about directions in respect of a case, ADR has to be very much in the parties' minds and in the court's minds. CPR Part 3, sorry, I am rushing through this, so I do appreciate, but time is a little against us. But CPR Part 3, the court's general powers of managing cases. Again, there has been amendment, and the amendment is set out there as a new Rule 310. And it says that the court may order the parties to engage in ADR. So just going back to Lyndsey's point about what the court's powers are, can they order parties to engage in ADR? Well, we can clearly see as part of the court's general case management powers, if the court considers it appropriate to do so, the court can now, in civil cases, order the parties to engage in alternative dispute resolution. In terms of track allocation and the directions that the court can order when managing a case, again, both in respect of the fast track and in respect of interim track cases and in respect of multi-track cases, the courts must have in mind ADR. So in respect of the first change, a change to Rule 28, the courts should consider whether or not to order or encourage the parties to engage in alternative dispute resolution. And again, that is repeated for the purposes of multi-track cases and the changes to Rule 29 of the Part 29 of the CPR, which states that when the court allocates a case to the multi-track, the court will give directions in respect of managing that case. And when given directions, the court must consider whether to order or encourage the parties to engage in alternative dispute resolution. So it's reminding the court at every stage of the claim that alternative dispute resolution is available and the court must consider it. So what if the parties do not engage in alternative dispute resolution that the court has ordered? Can I have the next slide, please, Nisha? Part 44, Rule 44.2. Again, there has been an amendment. And as with so many things in civil jurisdiction, the penalty lies in cost orders. Again, I was listening to what Lyndsey was saying, that in the family jurisdiction, ordering costs hasn't necessarily been the theme, but is becoming a theme. But we are all familiar that in the civil jurisdiction, costs really can be a major sanction and can be a very useful tool to encourage parties to engage with the process that the court orders. So what can the court do? Well, of course, the starting point in CPR 44.2 is that the general rule is the unsuccessful party will be ordered to pay the costs. However, the court can have regard to all the circumstances when deciding what costs ordered to make. 44.24 that the court can have regard to the conduct of all the parties, and we now know that that expressly includes, under new Rule 44.25e, whether a party has failed to comply with an order for alternative dispute resolution or unreasonably failed to engage in alternative dispute resolution. So that is the sanction, effectively a cost order. So they are the main changes to the CPR, and a recent case, thank you to David Watkinson for highlighting this, a recent case you'll see in your slides there concerned, case of Charles Elfink and Times Media, concerned a libel case brought against the Times newspaper. And really the argument at the very end concerned cost because the case was withdrawn. And the argument was whether or not the matter should be resolved by way of detailed assessment or whether or not the parties should be ordered to engage in ADR. And at paragraph 137 of the judgment, Master MacLeod explains why ADR was ordered. And in summary, the judge's position was that the costs of a detailed assessment, the time involved, possibly the hearing time involved, engaging solicitors and preparing for that detailed assessment were great. And of course that those could easily, or the matter could easily be addressed or should be addressed by way of ADR. And so you see sort of halfway through that paragraph, the judge ordered as follows: the time for commencing detailed assessment is to be extended until conclusion of any such mediation or the point at which either party indicates it's not prepared to proceed and wishes to go to assessment. Any party which decides not to engage in ADR as above, or to call it off, must be in a position to justify that non-engagement to the cost judge and be alert to the provisions of CPR 4411 and indeed the developing common law since Churchill. The judge also commented in that case is that they expect ADR in cost matters where detailed assessment is being considered to be the norm. And so it will be the preferred option to resolving cost issues rather than going to detailed assessment. And so we are beginning to see the courts very much now responding to the changes in the civil procedure rules and having ADR very much at the forefront in their mind, not just in terms of the litigation itself, but in terms of the costs that flow from that litigation. I am very briefly going to mention further developments in the civil procedure rules, which are particularly important for litigants in person. And this is the compulsory mediation changes in the in small track claims. There have been a number of pilot schemes looking at how mediation can be used to resolve what the courts consider relatively straightforward claims. And I'll briefly mention those at the end. But what has now happened is that there is now compulsory mediation in small track claims that do not apply to road traffic, personal injury or housing disrepair claims, but they do apply to money claims, specific money claims below £10,000. Now, in practice, the way this works is if the claim is within the compulsory mediation scheme set out in Part 26, the claim is stayed for a period of 28 days. A date is identified where both parties are available, and they will be given 1 hour's worth of free mediation. So effectively, there's a telephone call, one party is spoken to, and then the other party is spoken to, and there is an attempt to resolve the claim, which is then hopefully, if it's resolved, then there is a type of Tomlin order that's completed, that's drafted and sent into court. And if it's not resolved, the matters go to trial. And again, if one of the parties does not comply or does not engage with the mediation process, they have to explain that to the court. So I've set out in my slides very briefly what these rules are and when they will and will not apply. They do not yet apply to the majority of online claims. They are essentially for legacy type claims or paper claims. The pilot scheme came into force on the 22nd of May 2024 and it will run until May 2026. I'm afraid there isn't much information at the moment as to how the pilot scheme is going, but it is an important scheme. It's a type of watch this space, and I'll be interested to see what the statistics are on how successful some of these claims are. I briefly set out here, as I mentioned earlier, when the claims that they do and do not apply to, and I've set them out there for reference purposes. Compulsory mediation is offered once the parties have filed their questionnaires post-pleadings. And again, there is no opt-out. If the claim falls within the compulsory mediation scheme, then there is no opt-out provision. Previously, there was an opt-in provision, but that's now gone. And there are, as I mentioned earlier, potential sanctions if a party does not comply with the compulsory mediation service. The party would have to explain to the court why they unreasonably refused it. And these are the previous mediations pilot schemes that I refer to. And you'll see that the top one was the housing mediation pilot scheme. The reason I refer to it is because we now have a compulsory mediation scheme for small track claims. It's been on the agenda for other types of claims like the pilot scheme for the housing mediation service. I say watch this space because I think if the small claims track pilot scheme is deemed to be successful, and we don't know the outcome of that yet, and we won't for a number of years, then I suspect it will be possibly looked at for other types of areas, such as housing possibly, or as I say, other areas. So that, I think, brings me squarely within my time, Liz, if I'm not mistaken.
It does. Thank you very much indeed. Thank
Good,
you.
thank
There may
you.
well
And I'll
be
take
some
questions at the end. Yeah.
Marina. So on to David to explain how mediation works and how you can make the most of it. David, over to you.
Thank you very much, Liz. So my topics are preparation for a mediation, the advantages or disadvantages of early mediation, and I'm going to call that last when to have a mediation. So this is headed practical steps before a mediation. I'm addressing parties who have started the mediation procedure, whether represented or unrepresented. They have already decided to try and settle their dispute by mediation. They have agreed that with the other side. They have agreed on a mediator and a date and location and usual practice, they have signed a written mediation agreement. So now comes the next step, preparation for the mediation itself. What I'm about to say is the usual practice, but it's important to emphasize that mediations are party-led. So the parties can vary the practice or not do it at all, so long as they turn up at the mediation, of course. That should be expected at the very least. Before I go any further, I would like to say the parties should bear in mind, firstly, the purpose of the mediation. What is it? It is to settle the case, if possible. Now you are thinking Watkinson is stating the blindingly obvious. You might think so, but I have been surprised by the number of occasions when the implications of this have not been thought through by one or both of the parties. Not always, but on occasions, I have come across the attitude, I am willing to settle if the other party concedes my entire case, or near enough. This is not realistic. Settlements are usually reached by both parties being willing to compromise, and compromise can mean being prepared to give up a claim or part of a claim which might succeed if the dispute went to trial in the interests of settlement. So compromise means making concessions, and a concession should be obvious so that the other side can understand that the other party are giving them something of value and they should do likewise. Salami slicing is not recommended. Secondly, the parties should bear in mind the role of the mediator. The mediator is impartial. The mediator is not a judge or an arbitrator. The mediator hears no evidence, makes no findings of fact as to who is right or wrong, expresses no view as the outcome of the claim. Mediator does not advise. So what does a mediator do? The mediator is a facilitator. That means the mediator assists the parties to come to a settlement. The mediator hopefully enables the parties to look into the abyss, to consider the strength and weaknesses of their respective cases, the effects of the loss of the claim and the benefit of settlement. And secondly, bearing all that in mind, whether a settlement is achieved or not is down to the parties. It is their responsibility. Finally, the parties should bear in mind the usual procedure at a mediation. So there we are. This is the usual procedure. The mediation begins with a joint session between the parties and the mediator. The parties present their position statements, coming back to that later. That is followed by a discussion between the parties and the mediator. And then usually the mediation breaks into private sessions where the mediator speaks to the parties separately. Possibly the joint session is reconvened if the mediator considers that the mediation will be advanced by doing that. Hopefully, there will be settlement offers, negotiation, agreement, and finally, the agreement will be drafted, signed, and becomes binding. Now, if I can take you back mentally to slide 1 and pick up at prepare mediation bundle of documents. I have put that ahead of position statements, although that does mean that the mediator usually receives documentation without knowing what the parties are saying about the issues and preferred outcome. Bearing in mind what I've just said, the purpose of the position statement, I'm going to take that, is to inform the mediator what the dispute is about and what are the points of difference on the facts, if any, and the law, if any. No argument is required. All the mediator needs to know is that there is a dispute and what it is about. It is optional at that stage whether a party include a passage intending to persuade, tactfully, the other side to agree a settlement, either by demonstrating the strength of the party's case, but in the interest of settlement would accept the following terms, to state concessions or make an apology if appropriate. Bear in mind that the position statement presentation at the mediation may be the only occasion when both parties meet together and have the opportunity to address each other directly. This is a moment when persuasion is possible. The mediation bundle. Bear in mind the same principles apply for the preparation of the mediation bundle as apply to the position statement. So my suggestions for the bundle are the statements of case, assuming a claim has begun. There it is. Then witness statements, including expert witnesses, if any, court orders, particularly those referring to mediation, offers of settlement, including Part 36 offers and responses, and any other correspondence or documents relevant to the mediation. I emphasize relevant to the mediation because routine correspondence, documents which do not have further understanding of the claim or repetitious are best left out of the mediation bundle. And finally, and this is very important, the bundle should include, or the mediator be informed at some stage, of the total of costs incurred to date of the mediation and the estimate of costs if the case goes to trial, because this shows what the parties are putting at risk by not settling. And this part of the information sometimes comes as quite a shock to the parties concerned. I mentioned before that mediations are public-led, so there can be variations on this procedure. Unless contractually agreed, there is in fact no obligation the parties to do any of the above, except perhaps the first 4 steps and the last 3 of slide 1. Obviously, it will assist the mediation on the day it takes place if those steps that I've referred to are taken. Then joint sessions, they may not take place. The parties may be too outraged, or one of them too outraged at their treatment to agree to a joint session, or too fearful of intimidation. Although this happens, this is not, in my view, a good sign, as the joint session is the best opportunity for each side to understand the other's position and how the mediation is likely to develop. Other variations, the joint session, just the representative might speak, but the party, him or herself, can speak also. Again, this might be the only occasion when one party can hear direct from the other before the trial. Party may want a friend or relative to attend for moral support. Usually, and this would be a mediator's suggestion, the mediator will arrange a meeting online, possibly with the parties or representatives, or there will be an exchange of messages between the mediator and the parties prior to the mediation day to make introductions, go over practical details, and the parties can also speak to the mediator privately or send documents for the mediator's eyes only, or indicating what the party would settle for. And indeed, the same can take place at the mediation itself. Now, final topic, when to have a mediation. So the first point is mediation can be held at any stage, even before the claim is issued. And a mediation can be proposed in the letter before claim, or a mediation can take place right through to just before the hearing. All that I have said about preparation for a mediation applies equally to whatever stage of the claim has been reached. But the advantages of mediation at an early stage are, firstly, limited costs have been incurred, so settlement may be easier to reach as parties have incurred little, but are putting more costs at risk by continuing. And secondly, that at an early stage, the parties' positions may be less entrenched and alter as litigation proceeds. It may also preempt a court order to mediate if that order looks likely, and an early stage one party's case may look strong, which encourage that party to propose mediation, but for the same reason the other party may not be prepared to agree. So that's why I say, in principle, the best occasion for a mediation is when both parties are willing to discuss settlement. Having said, and the earlier the better, but having said that, I have known hearings to be close, but a mediation takes place even at that stage. So I'm going to conclude there, but with just an observation that when I was in practice, it was a feature that many cases settled at the door of the court when all preparation had been completed and counsel, solicitors, clients, witnesses were all assembled. Why should there be a settlement at that stage, I wondered. The answer, partly, is because that was the first time all the persons concerned in the case were gathered together in one spot and discussion could take place. And I thought, surely there can be a way by which that could be achieved earlier. Well, there is, and it's called mediation.
David, thank you very much indeed, and thank you for explaining the practicalities of how mediation works and why it can be so useful. We've currently got 3 questions in the Q&A, which I think we've got time for certainly the first 2, and we'll see if we can squeeze in the third. So the first one is to Lyndsey, and it is this. Is the child inclusivity in mediation becoming more standard procedure? I've worked on the periphery of these proceedings for some years with children, and it's been relatively rare that children are included in mediation. Lyndsey.
I think that's a really good question. Yes, it's the short answer. I think it is becoming more common. I don't want to overstate that because mediators, like solicitors, will always be quite cautious about putting the weight on a child of feeling like they're making this decision for their parents. So it really is just about feeding in their views rather than any kind of focus on that. I think there's a couple of factors that make it more common. Court delays have been the case for years in the family courts, but since COVID, particularly with private law cases, they really are quite extraordinary sometimes, particularly if you've got a case which is struggling to move forward. There is more training for child inclusive mediators now as well. So I was accredited in 2018 and it was compulsory at that point. It's been around, but it's becoming more of a focus. And again, I think all mediators were quite aware of the forthcoming family procedure rule changes for quite some time, that there's been a real direction of travel towards making mediation much more of a focus in the court proceedings. So all of those factors, I think, combined makes it more common, yeah, but certainly not every case.
Brilliant. I've got two that are I've got a general one which I'm going to ask David to deal with. I've just sent it to him, so I hope he's had a little bit of time to think about it. How can mediation avoid prejudice to later court proceedings if disclosure and admissions are encouraged during mediation to enable full exploration of the dispute, but those same disclosure admissions might not otherwise be made in court proceedings? David, can you help us with that?
Sure. Well, the answer to this is the principle of confidentiality. When the mediation agreement is signed, the parties will have agreed to keep the proceedings relating to and at the mediation confidential. And that means that what is raised in the mediation, documentary or in the course of what's said, cannot be relied upon in any subsequent proceedings. And exactly the same goes for any communications between the mediator and the parties. So what the mediator says to one party is confidential from the other party and vice versa, nor can the mediator say what happened during confidential communication with one party to the other party without that party's permission. So that is the rule. Now, of course, realistically speaking, although the documentation and what's been said can't be relied upon at the procedure, at the mediation, that inevitably remains in the heads of the participants. So that is a fact to be borne in mind. But so far as the court is concerned and the proceedings at the court is concerned, if the mediation failed, the mediation never took place. And that is mitigated somewhat perhaps by the fact that most mediations do not fail. They are successful and the parties come to an agreement. Perhaps not the ideal agreement they'd have got if they'd got a court order after a trial, but something which is of advantage and which they...
And I'm going to turn to Marina with this, and I'll just say a few words before I turn to her. From a housing caseworker at a law centre, usually only undertaking legally aidable work and thinking that mediation isn't normally possible in her cases because of the gulf between what each party wants. Interested in hearing on how we may have used mediation in e.g. homelessness appeals or possession claims, where it seems to be very difficult to introduce mediation. In disrepair or antisocial behaviour cases, mediation is more hopeful, and so the caseworker wants to know about that, and also how we fund mediation. Before I turn to Marina, I would say mediation can achieve wonders. And for example, in a homelessness case, where obviously the issue before the court is there an error of law in the local authority's decision? But actually the issues between the council and the individual aren't about errors of law. They are about whether or not the person's going to be accommodated, for how long, can they be helped to find alternative accommodation, and so forth. And so getting everybody round a table can achieve miracles, even if the legal issues seem not possible to be resolved except before a judge. That's my general point. Marina, can you help us on possession and home?
I do agree. I mean, the question refers to it being easier for antisocial behaviour and disrepair type cases. I think that's fair. I think I can see why that would be the case. But I do agree with Liz that they can work wonders. I mean, what the outcome of the pilot mediation scheme for possession proceedings was not particularly successful because there were very, very few referrals. So it was very difficult to evaluate the outcome of that pilot scheme. What they did say in the report was that those those cases that were referred to the pilot scheme were generally successful at mediation. So that was their finding, albeit that the number of cases that were referred were quite low, but the outcome was that those were generally successful. And so I suppose one can say that that's promising, but I think part of the difficulty with housing cases is not so much the concept of mediation itself, but how the mediation works. So, for example, if we look at the small claims track mediation, that's a 1 hour mediation. I'm a little bit sort of concerned as to how that's going to work in practice. I think if we had a mediation system that was mediation as we know it, the sort of mediations that we've been talking about today, the sort of mediations that David's been talking about today, I'm quite hopeful. I think more can be achieved in housing mediation cases, whether it's possession or homelessness cases. So I think it's more about how the mediation works, how the mediation is structured, rather than mediation itself. So that's what I would say.
Thank you.
That question.
Thank you very much
Yeah.
indeed. We did have more questions, but I'm aware of the time, so I'm going to wrap up. I mean, I would also say that obviously I hope that any of you who are unsure about mediation, we converted to its benefits. But any good mediator will be very happy to talk to the parties or the parties' representatives at a very early stage, just about the concept of mediation itself and whether or not then mediation would be appropriate in that particular dispute, and they would do so on a confidential basis. So if you have doubts, if you think the golf is too great, but everybody's talking about mediation, speak to the mediator in advance, see what he or she says. Please, I do want to thank you all for joining us. The slides and a link to the recording will be sent out shortly after the lunchtime today. Somebody said a great way to spend lunchtime, so thank you very much indeed. A feedback form will pop up when the Zoom ends, and we do appreciate your feedback, so please fill this in if you're able to. Garden Court regularly provides lunchtime webinars, and the next couple, there's one on the 12th of November, which is a week's time, on director disqualification, criminal and civil proceedings. There's one on the 20th of November, children's rights, ending the school to prison pipeline and promoting universal children's rights. And I think it's right, Anusha, that we've just advertised one on the 27th of November about the relationship between homelessness and accommodation that can be provided under the Care Act. And you are probably all on our events list, and you will get information about the webinars, but the information is also on the website, so you just keep a close eye on the website. And the link to the third webinar has just been put up. If we were all sitting in person in Garden Court's seminar room, I would ask you to thank the solicitors by a round of applause. You can't do that, but I'm seeing from the thank yous that come up in the chat that you're very happy with our speakers. Please do fill in the feedback form. Thank you very much, and have a good afternoon, everybody. Bye.